Well, hello, Linda.
Good morning, Mike.
For those that haven't come across you, and since you're not actually grown up in the pharmacy world, tell us who you are. Give us a little blip of what you do, why we're talking this morning.
Sure. So I'm Linda Clark, and I'm a partner at Barclay Damon, which is one of the larger firms outside of New York City, in New York, and in the Northeast generally. And I'm the chair of what we call the Healthcare Controversies practice area. And what that means is that we are cross-trained litigators, career litigators with a lot of trial experience, but we're also trained in the substantive field of healthcare law. So our firm has this interesting hybrid area where you do have lawyers with a lot of training in particular areas. For me, a lot of my time is spent on healthcare litigation generally, and more specifically in the area of pharmacy law and pharmacy litigation.
Okay, so Linda, back up here. When you say training, is this on the job training? Is there any official certification or anything? Or is it like an emphasis, and through that emphasis, you've trained yourself?
Yeah, that's a good question. In the law, unlike some medical specialties,
Yeah.
we're not generally allowed to consider ourselves quote unquote specialists. There's a few exceptions to that, like patent law and other things like that. But we are able to describe the areas of focus where we spend a lot of time. For me, I was a litigator, meaning someone who's in court frequently in a healthcare law firm.
Oh, I see.
So I became the go-to litigator for a lot of different kinds of healthcare problems that needed the skills of a trial lawyer, as opposed to someone who might do the contracts and the regulatory work.
Gotcha.
So that's how that evolved. What we found is that, unfortunately, our healthcare clients have more and more need for lawyers with those kinds of litigation skills or advocacy skills.
Yeah, right.
And so that has, in and of itself, become a huge area of focus. And that's why we now have a substantial practice group right in our firm dedicated just to healthcare.
So, Linda, you worked for a firm that specialized in healthcare. They found they needed more people to be litigators, which is good for you guys. And unfortunately, it's maybe a sign that there's more fighting going on, for lack of a better word. And then somewhere in there, did you find even more of a focus on pharmacy instead of just healthcare in general?
Yes, and the way I came to that was through a series of audits that had became very popular in New York and beyond. We have a very aggressive Medicaid Inspector General's office.
Yeah.
And we found that many of our pharmacy clients were just being deluged with all kinds of audits involving very high stakes. And it was becoming sort of an existential threat to the pharmacy clients. So that became a very big deal, I'd say about maybe 10 years ago, something like that. So that was the initial foray into that area. And then very quickly, we saw the influences of the pharmacy benefit managers,
Right,
in a lot of different ways. And so because we had that expertise with the pharmacies litigating these heavy-duty audits from the federal government, from the state government, it was sort of a natural segue to want to have the ability to protect them from some of these, the influences of these PBMs, which we know since then have become, just so destructive to the community pharmacy area.
I came across you on LinkedIn because you were commenting on some stories and stuff from pharmacy. Would this be correct in saying that you are responsible for your own client marketing? In other words, do you go out and try to be in the marketplace because you don't have people just knocking on your door or a marketing firm for you? You're responsible for those relationships, which then can turn into clients. Would that be fair to say?
That's exactly right. Like most law firms, it's very relationship driven, but there's also a broader marketing component. So especially in this area that we're talking about, which is pharmacy law, we find that substantial entities that are in the pharmacy space really want lawyers that know what they're talking about, that know the landscape. And so I use LinkedIn, something like this, for example. I write frequently. I speak frequently at national events. I use that to get the word out that we're interested in teaming up and representing pharmacies in substantial matters.
So it's two things. It's getting your name out there, but just having your name out there saying you represent pharmacists is not enough. You've got to get out there and show that you understand the problems and you're on the side of the pharmacist and things like that. So that builds up that trust more than a billboard's going to do that just says you're a pharmacy specialist.
Right. And you mentioned the trust issue too. And that's very important here because many large firms with the depth and the sophistication for the kinds of issues that we're probably going to be talking about today also have significant conflicts of interest. So one of the things that we've done within our pharmacy law group is we've conscientiously avoided big conflicts by avoiding representation of payers.
Yes.
We know that there's so much we call it vertical integration with payers and PBMs that it's very hard as a firm to ride the fence. So we have chosen a side in this battle, and it's squarely on the side of the pharmacies, the independent pharmacies specifically.
How far can things go in your mind? You know, they start out small, but things can take off, right? And that's where a bigger firm comes in handy that's not going to run scared.
Right. And what you want is a big enough firm that you have a bench of lawyers with the expertise. They're not going to be out day one of a major audit with a withhold or something that you might be experiencing and going to find the PBM manual or starting to research the law. If that's happening, it's going to be tough going. So what we have is really kind of a SWAT team, I would say. We're ready to go, and our clients end up in very significant disputes that are different than anything else. These are not slow-burning projects. Many times we have regional pharmacies that are under tremendous pressure, facing either termination from one of the big, what is now the big three, right? Pharmacy benefit manager networks, facing perhaps 100% withhold with one of those huge entities. And so those are pretty much bet the company situations. So it's not unusual for us to have to literally parachute in. For example, I was in Honolulu, Hawaii just a couple of years ago. This year it's been Texas, Florida, New York, of course, New Jersey. And you really need someone with those skills and the knowledge to jump in on your behalf and really assist at the beginning in those difficult situations. But I'd add that even in the less dramatic situations where you're facing a large audit, we find it's really helpful to be involved in the beginning. Sometimes people wait until they have sort of a final answer from a governmental authority, Medicare, Medicaid, whatever we're talking about, or the pharmacy benefit managers. And by then, sometimes it's too late. The record's set. The arguments that need to be made have not been raised. You're then precluded, and it's a very big uphill battle. We just took on a matter which shall remain anonymous for now, but let's just say that this very healthy, vibrant pharmacy group was run out of business in their state by their PBM, and they kind of came to us for a second opinion after it all happened and the business was lost. We found immediately a law in their state that would have prevented any of that from happening. It's tough. It's not impossible at that point, but boy, if we had been involved at the beginning, none of that would have happened. There were, huge dollars involved, not to mention termination, that existential threat, right, we've been talking about. So that's one of the reasons that we've decided to really look at our practice more nationally. We're not in every state, but we have relationships with local firms that can support us out of the states where we have offices. We have maps here in my office that have all the states and what their state laws are, what the developments are legislatively in each state, because as you probably know, there's this layering of laws. You have pretty limited protections under federal law, and then it sort of marries up with a lot of the local laws. And then on top of that, you have the rules that pertain to each contractual relationship. So it might be your PSAO agreement. It could be your pharmacy benefit manager agreement. And so it's a pretty complex quiltwork of laws that define what your rights might be under a certain scenario. Honestly, with Express Scripts and Optum, we're talking about two of the biggest businesses in the country. Certainly in the top 20, looking at United Healthcare, for example. And so the stakes are very high. If you don't have a firm that has the reputation, the expertise, and the guts to push back in those scenarios,
Right.
you're going to have a difficult time. And unfortunately, then you get the letter, the "we'll buy your pharmacy" letter. Sorry, you're having difficulty. Maybe this is your way out. That really troubles us as lawyers.
And it's way too coincidental that they don't know about the audit or the lawsuit that's going on.
Well, exactly. I think they claim that there's a firewall internally. Let's say CVS, Caremark, and they don't communicate. But I have sadly seen in these scenarios many independent pharmacies get pressured into selling to the very pharmacy benefit manager owned or affiliated chains that are supposed to regulate them. And that's that. Now we're talking about that fundamental rub, that conflict of interest that makes pharmacists just shake their head and wonder, if there's any fairness or justice to be had in these relationships. And of course, that's one of the major issues right now before the Trump administration, the Supreme Court, and all the state legislatures is resolving that conflict of interest.
Pardon my French, and I know you speak French.
That's right.
Do you do a lot of that, or?
Well, I was very lucky when I was 15 in a public high school in New York, sort of in the Hudson Valley. I got an invitation to sort of try out for a Rotary Club scholarship in France. And so I took off for a whole year when I was a teenager and lived with 7 different families in France.
No kidding.
Through the Rotary Club. Yeah,
wow.
It was an amazing experience. And so I've done my best to keep up my French over the years.
Wow.
And try and go back. But yeah, I was very, very lucky as a kid.
Did that count as a year of school?
It did.
Wow.
So yeah, it was cool. I went to a French lycée, a high school in actually a socialist town in the northeast of the country, closer to Germany. And so it was a incredible cultural exchange for me too.
Wow.
And it's really definitely changed my path and opened my mind very significantly as a young person.
Do you use any actual French in your job at all or not?
Not as much as I like. It's very tough to develop a transnational practice, particularly outside of New York City and the firms that have that licensure.
Yeah, right.
In cross-border licensure. So that's a little tough. I mean, it's more of a social thing. So I won't be offended by your French.
There is no frickin' wall at those places because about every 5 years or so, I own an independent pharmacy in Grand Rapids, Michigan. And every 5 years or so, I price out my business and just see what it's worth and so on from actual offers from people. And we had some guy who said he was a former employee of a certain chain and we signed this confidentiality agreement and so on. And before you know it, somebody was calling us from there because they said, oh, we just happened to talk to them and we know you're the only pharmacy in Grand Rapids that, so they were trying to beat around the bush. It's like, come on, you guys, you're all one thing. There's no wall. There's no wall in those places.
Right. And it's very hard to imagine how they can do that. You have the related issue in terms of the wall concept with the pirating of patients.
Yeah.
Right. So we see a lot of examples where, you'll have an order come in or a script come in and it's a regular customer and the customer is getting direct notification that they need to go to the preferred CVS network.
Right.
And so that communication is going directly from the pharmacy benefit manager side of things and redirecting the patient away from their independent pharmacy or whatever pharmacy they're with and to a related pharmacy. And that's the subject of some very important litigation going on in various parts of the country. And we think that's just a prime example of the lack of any separation between that fiduciary function of being responsible for managing a benefit, but also competing in the same market space.
It's crazy. And they might have, and this is being generous, they might have avoided a HIPAA situation by not actually coming out and saying, we know you got this drug at this pharmacy and come to us. So they probably scoot around that a little bit, but it's all in one big ball of it's one big hairball that these places are in.
And they're not coming after your loser drugs in terms of the ones that you lose money on. They're coming after your quote unquote specialty drugs.
Yeah.
Anything with a profit margin. So It's I don't know. Sometimes I think it's pretty transparent.
Yeah.
But that's why all the state legislatures have stepped in. I mean, you probably know, but there's been this wonderful wave of state legislation that's been just on fire across the country trying to deal with this situation because God love our pharmacists. They have been just incredible activists on the state level and have been pretty successful in getting legislatures to implement reforms that would prevent those kinds of things from happening.
Let me see if I have this right, Linda. And you stop me. Well, don't stop me. Just let me embarrass myself. And then at the end, you can correct me. How's that sound?
Fair enough.
All right. 30-some states have set up these rules against the PBM antics. And the PBM says, screw you all, we're appealing all these, and they keep going about their stuff. And then Arkansas,
That's right.
Arkansas finally, a couple weeks ago, had the Supreme Court agree to hear their case. And if the Supreme Court falls on the side of the Arkansas, pharmacy lawsuit or the association, they then can finally say to the PBMs that are telling the 30-some states that have these laws, and the PBMs are saying, go screw yourself. We're not doing anything until the Supreme Court tells us we have to. That's what a win in June or whenever this would be would take care of? Where am I wrong on that?
No, I think that's a pretty good description of the situation. I think that the complexity is on the part of the case that involves ERISA, right? So PCMA is the trade association for the pharmacy benefit managers. And what they've been doing is very strategically selecting cases to take up on appeal where they think they can get the court to agree with them that the states have very, very limited ability to regulate pharmacy benefit managers.
ERISA, what is that?
Well, that is a huge, huge network of laws federally that govern employment benefit plans.
Okay, gotcha.
It really blankets a huge portion of the benefits that people have in this country. And the idea is that ERISA usually, in many circumstances, can preempt state law. So what the federal government has done is they've created a uniform law on the federal level. The pharmacy benefit managers through PCMA are saying, hey, look, states, you can't interfere with how these plans are being administered. It's covered by a uniform federal law, and under the preemption concepts, you're not allowed to come in at the state level and impact and interfere how these plans are being run under federal law. That's the gist of it.
So the PBMs, and I hate to give them any benefit here, but the PBMs are not just telling the states, screw you, we don't care about your laws. They're saying screw you because we think that there is a stronger federal law that supersedes all these piddly agreements that the states are making.
Exactly.
Okay.
So there is the Rutledge case that you're talking about, which is the Arkansas case. It's very interesting because just over the last few weeks, we have the Supreme Court agreeing to take that case. And apparently the High Court is willing to take that case and draw some lines and give some guidance regarding what the permissible scope of state law will be. So this is a very, very important moment. It's also very interesting that in December, the court, trying to figure out if it should take the case, if this is something they wanted to get into, used what I call as their phone a friend option and asked for briefs from the Solicitor General of the United States. And the Solicitor General came in and fully supported the Supreme Court's review of the issue and really came in on the side of the independent pharmacies and against the PCMA position. So we are cautiously optimistic that if the Supreme Court gives weight to the Solicitor General's sort of independent view of the situation, that it could yield a positive result here. But no one knows. It could go either way. And so we'll have to see how the Rutledge case comes out.
How long does a case like this last? A year?
Yeah, it could last a year. There's a few things that are uncertain yet in terms of briefing and the like, But there was a writ of certiorari, which is the permission slip, so to speak, that was granted last week, I believe. So over the next year, we'll see the case move through the court's normal docket.
How long is a case like this physically in front of the justices? How many hours? Like 1 hour, or like how long are they actually like in front of the judges?
Not very long at all. Sometimes you're talking about minutes.
Just enough to get it in the cycle and...
Exactly. Now, what I'm talking about is the oral argument. The case itself will be fully briefed. There'll be very sophisticated legal work done, and then the justices will hear argument for a very short period of time and then issue a decision.
And the arguments could be minutes.
Absolutely.
Assuming they did all their homework and that, and just enough time for Clarence Thomas to get out there and not say anything.
Yeah, some of our justices are much more active than others. Sometimes you have a hot bench and sometimes you don't. But I think what's interesting about this case is the impacts of the case generally on this concept of preemption. I think that many of the states, like New York, you might have heard, unfortunately, we had a rather comprehensive PBM reform bill.
Yeah.
Unfortunately, it fizzled over the holidays. The governor vetoed it.
Yeah.
The veto message and the messaging from the governor suggested that they weren't sure if the law would be upheld because of all the uncertainty over this Rutledge issue. And so if Rutledge goes the way of the independent pharmacies, then I think that state laws will be much, much bolder in reining in bad PBM behavior. If it goes the other way, then maybe it's something that Congress needs to take up in a more comprehensive way. So to me, that's sort of the crossroads that we're at.
An appellate is more like they're not retrying the case. They're just usually looking at the one part. It'd be like if my kids are fighting over something, they can't come in here and tell me the whole damn story again. If I'm the appeals judge, I'm just saying, all right, what actually happened in this part of it? That's kind of what they're doing. They're just hearing the appeal of this whole case that someone thinks is wrong.
That's exactly right. And even the Rutledge case really deals with a subset of issues. So to the extent the state can regulate the business side of pricing, for example, pricing appeals, pricing limitations, trying to make sure there's some floor of reimbursement for pharmacies. That's one of the issues in Rutledge. It may not decide other issues like open networks, like some of the other reforms that we've seen in other states. But if it gives us guidance on more generally on this principle of can the state governments regulate side by side these plans with the federal government, that's going to be, in my view, one of the important outcomes of the Rutledge case.
If the Supreme Court says, all right, they can do this part of it, don't the PBMs just say, all right, we'll give you that one. Now here's another 99 things that we haven't heard from yet? Or is it very symbolic, too, that the Supreme Court, they might verbally say, let's say the states, you won this appeal, but wink, wink, we're also going to let you win the other 99. Is it symbolic?
Well, it depends on the decision. If the court says that the states have broad latitude
I gotcha.
To regulate, as they traditionally do, as you know, the pharmacy profession is generally regulated by states.
Yes, right.
And so that's why you have this sort of collision between the traditional state regulation of pharmacy and pharmacists and the ERISA
Gotcha.
regulation of employment plans on the federal side. And so it's this middle area that we'll probably be hearing from the court about. And if they could decide it many different ways, it could be very limited and allow a little slice of state regulation on certain kinds of issues, right? Or it could really shoot down the PBM position on some very fundamental issues that could give them problems going forward on this conflict of interest, for example. Lawyers, we're spending a lot of time thinking about all the different ways it could come out, but it's very difficult to predict exactly how it will go.
And there truly is a conflict. I mean, it's not just like they found one word and they're trying to fight something. There truly is. It's kind of like the federal against the states. I mean, obviously the pharmacists wanted to go one way, but do you think there's decent arguments on both sides?
Yeah, I think so. It reminds me of some of the things we're seeing in other related areas. For example, you have relationships with your wholesalers, right?
Yeah. Not good ones.
not as good as you'd like them to be, right?
We just want them to give us everything for free, and they don't want to.
Right. And as you probably know, many community pharmacies depend upon relationships with major wholesalers, but then also secondary wholesalers, right? Depending on what kind of pharmacy you have and what your needs are. And there have been some interesting developments there too. There we've seen the big PBMs team up with other actors like NABP, right? The National Association of Boards of Pharmacy, and create accreditation standards that you have to follow as a pharmacist. So, for example, I'm sure your listeners might be familiar with the VAUD program. So OptumRx has said, if you want to be in our network, then you can only buy from a VAUD accredited wholesaler. So over the last couple of years, we've been involved representing a group of secondary wholesalers that have been shut out of the marketplace effectively, or in significant part, because all of a sudden their pharmacies can't buy from them because they're not VAUD accredited, and because of the NABP standard on accreditation, they may never be.
Because they're not big enough, or there's something that VAUD's got some weird parameters.
Right. And VAUD, it's very esoteric, but they don't want, first of all, they generally only have huge wholesalers in their accreditation list. They don't like secondary wholesalers. Generally, they really put them through, I think, a too stringent process for accreditation, and it's effectively wiped out a huge swath of the secondary wholesaler market. Many have just gone away. So the pressure on the pharmacies through the PBMs using these accreditation tactics, right? You know about other accreditation problems too, right? You have to be URAC, or you have to be, it's all these different accreditation VIPs. And if you want to mail order, if you want to be a quote unquote specialty pharmacy. And so the proliferation of these accreditation standards on the competitive side, which, is very important to pharmacists to be able to get their products, just like everybody else. They need to be able to get quality products at a decent price to stay in business. And then from the top, the incredible pressure you're under from pricing, from the pharmacy benefit managers, from the abusive auditing practices, all of that. It is a very tough spot right now for the pharmacists, and I think a lot rides on the willingness of the states to step in and rein in these improper abusive practices, really before it's too late for community pharmacy.
For sure. I know the NCPA, I think, or somebody said that within 2 years they're looking at 50% of the pharmacies closing or something like that.
Right. And I don't think people realize, I think it's the kind of thing that's so distressing for pharmacists that they really, it's almost a little bit of the head in the sand approach sometimes. Very hard to get them to realize that there is this, right now, it's happening in real time. And we're losing that sector of community pharmacies at a rate that is very, very alarming. And NCPA is great, PUT is out there, even NASP is out there, trying to raise awareness, trying to support the efforts of some of the states, trying to empower pharmacies to fight back when it's appropriate. All of these organizations are working very hard to get the word out and empower the community, the independent pharmacies, to protect themselves from this really onslaught of terminations.
It kind of sounds like when you were talking there, I hadn't really thought about this. I've spoken about it, but I haven't thought about the reason. But I've been at the pharmacy, my grandpa and then dad owned it, and they've passed on. But I remember working with my dad years ago, and the insurances would say, all right, we're going to, instead of being AWP plus 15 or something, we're going to AWP plus, 12 or something. And I'd start to panic, and my dad would say, well, don't worry about it. The wholesalers are going to catch up, and they're going to compete and lower the price accordingly, so that spread will be there. And that seemed to always happen. Then of course, it went to AWP minus, but then a week later, the wholesalers would come in and they'd offer this and that, so that spread was always there. It almost sounds like, because of all these people sleeping together, it almost sounds like part of the reason why it's not catching up again why that spread keeps going down, among a ton of different reasons. But one of those is because of things like VOD, where they're all in bed together and they're making it hard for competition. And so pharmacies were used to being pressed from the top, but we used to have a way out at the bottom with the competition of things. But it sounds almost like the VOD is saying, well, we're going to have false competition or take away the competition by making it so hard for new players and new people to be in here. And we're in bed with the wholesalers that's where that squeeze finally no longer has a flexible bottom to it.
I think that's exactly right. And that's very anti-competitive in its effect. So that's why that's a big problem, not to mention the price tags put on some of these accreditations. So,
yeah.
If you get your prescription delivered, right, or mail ordered, that can be a problem under some of these plans if you don't go get a special accreditation and pay tens of thousands of dollars for an accreditation. And some of the PBMs are really trimming their networks through the use of those kinds of accreditations.
Tell me about that, about delivery or mail. What do I mean by that?
Sure. So many of the pharmacy benefit managers structure their networks so that you can only mail order or deliver if you are part of that mail order network.
That's what I thought you were getting at, where the pharmacy can only do 5% of this, or can only mail out so many percent or whatever, that kind of stuff, right?
That's exactly right. And in the modern world of the Amazonian world of everything shows up on your doorstep, we really question how on earth that makes sense now.
Right.
How in any pro-competitive way you can justify limiting a pharmacy's ability to deliver or even mail order under appropriate circumstances. That's not to say that there's not some drugs that are more sensitive temperature, whatever we're talking about. But for the vast majority, that's what consumers expect. And in the modern world, it's hard to imagine how you would have to pay tens of thousands of dollars for an accreditation in order to avail yourself of that sort of basic mechanism of delivering and mailing.
The accreditation might say we are now officially a mail order pharmacy, and so we can do a higher percentage of this and so on.
That's exactly right. And as you know, the pricing is different too in the mail order networks. So you have to make a decision as a community pharmacist or an independent pharmacy, or even a small chain, independent chain. You have to decide if it's worth the pay to play, given the impact on the pricing. But I worry about those kinds of rules because it might get more difficult over time with PillPack, everything else going on, apps for everything. I worry that it's just another way of driving independent pharmacies into a corner where it's so difficult to compete.
Here's the thing that bothers me about that is I've never been one to say to people, well, you should come to my pharmacy because I've got my starving children and I've got to do that. I never liked that pity party of being a small pharmacy, but it's really frustrating when they throw in these oddball laws really for no arguable reason. They're just throwing those things in, like the percent of delivery or the percent of mail or this and that, because that's just plain old stopping the competition or the different co-pays and that kind of thing. We don't want favors as independent pharmacies. We just want level playing fields. That's all we want. But when they start throwing in this delivery ratio and mail ratio and that kind of stuff, that doesn't seem fair.
Yeah, and I agree with that. The newest thing, we actually just blogged on this, but a good example of this is the new aberrant quantitates rule, right? So you have one of the PBMs coming out and saying, we're going to have even though these drugs are on the formulary, and the patients are entitled to get these drugs from their plan, right? They're all approved. We're going to punish pharmacies that dispense too much of the following drugs. And so they have a sort of a naughty list of drugs that are on this list, and they're going to audit pharmacies and decide whether or not the pharmacies are ordering too much of a specified set of drugs. And that's really problematic too.
Yeah.
This is a brand new rule. We're looking at it. It looks like it's drugs that have some profit margin, right, to probably offset the penicillin that you lost
Yeah,
couple bucks on,
right.
right? And so it's just another way that we see the pharmacy benefit managers creating a self-serving and anti-competitive environment that really hurts pharmacies.
Is that an audit flag, or are they actually saying you can't go above a certain amount of these drugs?
They're going to be auditing on it. This just came out, and we've been actually trying to get information from the PBMs so we can advise our pharmacies about what the mechanics are going to be.
Yeah.
And we're right in the middle of that process right now. So right now they're just saying that aberrant quantities. So if it looks too much, that could be a problem. We think that, again, that's the kind of thing that the states might want to take on.
And if it's not too much, we're going to come and harass you for it anyways.
Exactly. So, those are some of the things we're seeing right now on the cutting edge of this area. And so there's a lot riding.
You were mentioning states and federal and so on, and that's why a lot of times as pharmacists, we just don't know. For example, the new fad or whatever, CBD oil, and people are always calling our pharmacy, and I've had questions about this 3 years ago, and my answer is, I'm not going to listen to a salesperson to tell me what the law is. I'm going to just watch Walgreens down the street and CVS and these stores, and once they carry it, then I'll think about carrying it. But they're my canary in the coal mine of what's legal, because I know that the minute it becomes okay to do this in the area, they're going to be doing it. And until that time, I tell these salespeople, the ones that I talk to or the email I get or whatever, it's like, no, that's who I'm watching. You can say what you want about laws, but you can also pick and choose a state law that's overridden by a federal law that they're not telling you about that.
Yeah, you definitely don't want to get your legal advice from the salesperson.
No.
Actually, there's a lot of issues right now out there about how drugs are marketed to pharmacies and how pharmacies market to prescribers. That's an area of the law that's very interesting as well. And there's a lot of limitations on how you can interact with prescribers and any sort of gifts or things like that. What the big item that we see often is waiver of copays. Some pharmacies may have marketers out there, right, identifying prescribers and patients in a certain area. And, each plan, each pharmacy benefit manager, more specifically, has standards on what your obligations are to collect a copay, document it, what the standards are for follow-up, right? How far do you have to go chasing down a copay for a client?
So someone can't say, well, we told them that they owed this, but then they never send a follow-up or something. Well, that's not a real charge to the person then.
That's exactly right. And some of the rules suggest that even sending that to a collection agency isn't good, that you have to internally document multiple calls and contacts with the patient to demonstrate that you use due diligence in getting that copay.
You could use your brother's collection agency and they don't... They just say a prayer. That's how they want to collect it.
Right. And it could be, what they worry about legitimately on the other side of this is, wink, wink, nod, nod. You're going to have to pay this copay someday. We'll be in touch, right? And then the pharmacy gets a reputation for waiving them, and that becomes sort of an inducement for the client to come to you. And, the plans structure those copays so that people have some skin in the game, right? So that there's a balance there between utilization, and I understand that, and that makes some sense.
Right.
That kind of raises the big issue of the gag clauses, right? We did have some action by the Trump administration and in preventing gag clauses. So only about a year and a half ago, I think it might have been 2 years ago, you wouldn't have been able to say to a customer, hey, Linda, you're picking up this order, but I want to let you know that your $50 copay is more than I'm going to charge for the drug.
Yeah, right.
And so that was in a very egregious situation that was very well documented. You can imagine the profit margin for a PBM, right, charging in a copay sometimes double, triple what the item actually costs.
For sure. And how does that work out with, like, I know it's probably more detailed than this, but in my mind, Trump says, bad idea, not doing it anymore. Does that like wipe out then all of these contracts that say that? Or does a pharmacy say, yeah, the contract I have in front of me still says I can't talk about it, but I know that no one's going to press this because the federal law now says this is okay. Does that kind of wipe those contract wordings off, even though it's not officially off yet?
Right. So that's part of the problem, is putting the pharmacist in the position of having to sort of guess which law is going to govern under a particular set of circumstances.
I see.
And it's on the books, right? But the federal law would trump that. That would be unenforceable. In our communications with our clients, we blog a lot about these things and communicate with them. So they kind of know what's enforceable and what is not. And in New York and other places, another great place to look.
Yeah.
So you have your BRIC, right? Your PBM manual, 300 pages. You get an update by email, at least a link to an update, right?
Yeah, they're you don't even want to crack into those because they're so one-sided,
Right. And not only that, but they contradict state law. So what they do is they have an addendum. I'm always telling clients, look at the addendum for your state.
Yeah.
So at the back of the BRIC is a state-by-state addendum, and that'll tell you what the rules are typically for your state. And so you may have rights in your state, but you would never even know it if you didn't have the addendum, right? Or if you didn't look at it.
Right, because the BRIC itself is not going to be lenient and then say, go to the end to find us being more forceful. It's going to be as forceful as one state allows, and then the addendum's going to give them clearance.
Exactly. So that's a great resource for pharmacists, too, to keep track of what their rights are under various state laws.
Where's your hometown, Linda? Where'd you grow up?
Poughkeepsie, New York.
Poughkeepsie, New York.
You've heard of it?
Yeah, one of the, Chuck Mangione?
Yes. One of
the bandmates was from there. I remember the live at the Hollywood Bowl, and he would say, so-and-so was from Poughkeepsie, New York. I think it has to do with Chuck Mangione somehow.
It's about halfway between Albany, which is the capital of the state, and New York City. So it's sort of mid-state, you would say.
Okay, well, I was trying to give you a way out of this, but now I just have to ask it, and it's going to sound rude, but I guess they call us Midwest. But in the Midwest, we're all happy and nice, and the New Yorkers are all nasty. I've never experienced it because I've never been to New York, but they're short and you don't say hi to each other on the street and all this kind of stuff. And I hope I'm not bringing you any new news here. I hope you haven't just read about how everybody's real chummy over there.
Well, I think it depends on where you are.
How does that affect the law? Is the law any different because of that?
Well, it's interesting because I'm from, let's say mid-York, right? Which is halfway between the Adirondack Park and New York City. And I practice in New York, in New York City, in our New York City office. So you kind of hit on an interesting cultural difference between New York City lawyers and upstate New York lawyers. Very, very different vibe.
Okay.
I'm sort of cross-trained because I grew up in one area and I practiced in both.
Yeah.
You're right. I change my mojo a little bit when I'm going into Bronx Supreme Court.
So you do have to change something when you're in the city.
Yeah, a little bit. It's more driven by the attitude and culture of the other lawyers there who are much more, rough and tumble, which is fine. You just got to make sure you know which crowd you're running with, right?
Right. You have to know where you're waking up that day. And
yeah, no room for shy lawyers in New York City litigation. That's for sure. However, I will say, when the New York City litigators come from the Bronx or Brooklyn or wherever up to this neck of the woods in upstate New York, you can have the opposite problem. You have a very genteel bar, very genteel participants in the court system. And so the attitude that might go well in the Bronx doesn't always play well up here to our juries or to our court system. So everybody needs to modulate.
The judge might say, you don't talk to me that way kind of thing.
Right. Or my favorite thing is when somebody comes in and says, well, Judge, this is how we do it in the city.
Yeah.
Right?
Yeah.
Oh, boy.
Yeah, you don't tell the judge, and they know where you're from, and they have their guards up already for that.
Yep.
With all respect for customers that you have, whether they're in New York City or outside other states, do you see different attitudes / demands from your clients in New York versus maybe somewhere else? Are they, and I know you have to tiptoe around this one because they're your customers, but do you see a different way they want to deal with you?
Yeah, I'd say that's more metropolitan versus, I think it's more in the bigger cities where the clients are with bigger businesses.
Right.
So if you owned a pharmacy chain of, 20 pharmacies and you're in major cities and you're on 100% withhold with OptumRx and going to the pharmacy review committee for potential termination, you're going to be very outspoken, concerned. And so I think it's more the nature of where the clients are and what the nature and scope of the problem is.
Yeah.
That's a very different representation than some of my rural pharmacies in upstate New York, right? Where they're in their town, right?
Yes.
But they're facing the same kind of problem.
You never know how somebody will act, whether it's big or small, if their livelihood is one person's business or 100-store chain. It's often the same.
Yeah, and then there's the other area. Some of these problems, if you're not diligent in protecting your pedigree of your business with the PBMs or the government, these things can head toward much more serious outcomes too, in terms of fraud and abuse and having investigations crop up when you're red flagged by a PBM.
The pedigree, you're talking about the drug trail?
Well, I'm talking about, let's say you have an audit, right? And you've got inventory shortages, right? Yeah. And sometimes clients will say, you know what? I just don't want to deal with this. I'm just going to pay it. I'm not going to worry about it. It's just too much of a headache for me.
Yeah.
I really caution those clients, well, take a good look at it because the next step is going to be a recoupment. Right? Could be extrapolated, meaning that it's projected over all your sales.
We've dealt with that.
That's a massive headache. Then you could be flagged for the Pharmacy Review Committee, the PRC. They decide if you stay in the network or not. If you get kicked out of the network, you got to tell all of the other PBMs that you got kicked out of a network. Then you're facing termination by all the networks. And if they report you, let's say on a waiver of copay issue, something that they view as substantial or significant, then you're red flagged and reported to the OIG or the state OIG or Medicaid fraud. So these issues can tumble quickly, even beyond an annoying audit, into a much more serious problem.
And that can all come from just saying, all right, look, I don't want to fight this, so I'll just admit to it, even though I'm not guilty. That can all stem from that instead of trying to fight it, even if it's a couple $100.
I think, there's probably limits to that. So if it's a couple $100, I don't think I would tell a client that has the potential for that cascade of terrible outcomes.
Everybody would understand that for a couple $100, you usually give up or, give in.
Right. But if let's say it's with a local pharmacy, it's 15 to 20,000 on missing inventory.
Right.
What if it involves controls?
Yeah.
Right? Those can be significant issues. And even though you may want to put your head in the sand and not dig out your invoices and wrangle with your wholesalers to get those invoices to the PBM, there might be very good reasons for doing that. That's the long game that you worry about.
Yeah, you want to show some fight, maybe. It's kind of like the Hollywood stars that do or don't respond to harassment issues or something, and weak non-Hollywood people say, why did they not fight that? And then you say, well, there's a good reason too. And it's like, yeah, but wouldn't there be a good reason to at least there's those questions that we don't know from the outside, but it does make you question it at least.
Yeah, it sure does. The PBMs as regulators have to make that decision each time. Is this a red flag or not? Is it going to be reported?
Yeah.
So on that scary note.
Yeah. There's one person that you follow on LinkedIn, and I'm not sure if it's by just a wild click one time or not, but Bill Gates is someone that you follow.
I like to see what he's doing. I think that in his current role, he's been, in my view, a bit of a visionary with the global sanitary issues that he's dealing with.
Interesting.
Finding the, what could be the game-changing technology that will make, some terribly suffering communities more safe.
Right.
And so I find those things very, very interesting.
Yeah.
And so that's why I follow him.
Did you watch his Netflix special?
I did. That's why I ended up following him. You did too, obviously. I thought that was jaw-dropping.
Really fascinating.
Yeah. And the way they ran into problems now because of the current geopolitical scheme, was really unfortunate too. So those kinds of leaders I find very inspiring.
Yeah.
I try to keep my eye on them as I, work my way through my career and be inspired. It's not always easy in a litigation environment, but I think that's a great use of LinkedIn and things like that.
Bill Gates was really cool. They basically have a solution to using nuclear power and using old nuclear waste even for nuclear power, but it got stopped because of the accident over in Japan, whenever that was. And so it was just PR basically, which has stopped that for now because nobody wants to hear about nuclear power after there was an accident. It's cool to see somebody that's really tackling something that's not, what's the word for it? It's not sexy.
Right. Or self-serving, really, at this point.
Or self-serving. Yeah. It's not self-serving to, for Gates to say that I found out how to get half the world to be able to flush a toilet finally or something like that. It's neat to see real solutions. They're not self-serving. They're not trying to join a certain status club.
Right.
What kind of customers could best be served by you?
Well, what I see is that larger volume pharmacies really need a regular stream of advice. And so we encourage those larger entities to get a retainer with us and then use us as they have questions so they avoid trouble down the road. We have a team, in addition to our litigator group, we have a team that does pharmacy sales, very sophisticated transactions.
Selling of pharmacies.
Right, compliance plans, all those combining pharmacies, regulatory issues, licensing issues. So we have that whole panoply of legal work within the pharmacy group. With the independent pharmacists, usually, in fairness, they will call us when they need us. They'll usually get our name from one of the state associations, word of mouth, or, even LinkedIn or something like this, hearing a podcast. And they'll get a hold of us when they need us because they just don't have the volume or the budget really to keep a law firm on retainer in those situations. And that's fine too. We're happy to be there, when you need us. But the larger entities, multi-location, some of the regional chains, specialty, functions, mail order, those kinds of things all involve more sophisticated issues and probably require some more proactive consultation.
Is there any information that comes from you that people that are independents without an issue right now, they're hoping not to have an issue, is there any way they should be connecting with you?
Sure. So LinkedIn, I find, is a pretty effective, powerful tool to reach pharmacists. So I'm easily found on LinkedIn.
Is that where you're finding the most impact and so on with pharmacists now?
I think that's the best gateway to pharmacists, both directly and through their associations that they follow. So I'm lucky enough to be called upon to speak at some of these organizations, including, PISNI in New York, NASP in DC, NCPA, National Community Pharmacists Association. So we're meeting up in February at their multi-location conference in Fort Myers, Florida. So I'll be there. We'll have a booth, and I'll be making some remarks. We're a sponsor, so hopefully I'll see some of your listeners there.
How long are you there for it?
I'm going to be there for all 3 days. I think we're going to be introducing a keynote speaker and making some remarks. I think by February, I think people will still be very interested in the Rutledge case. So maybe I'll give a little bit of an update on that. And otherwise, it should be a great time.
What dates are that?
It's the 19th, the 20th, and the 21st of February. And it's in Florida, so it's not a tough gig, when you're from New York.
Well, Linda, it's been a lot of fun talking to you.
Yeah, thank you so much for the opportunity. A lot of fun to talk with someone so knowledgeable about something I'm so passionate about. So thank you again.
And likewise, it's cool to talk to somebody that has such a strong background in one field, but is able then to relate completely to my field. We know what the same terms are, and then you can talk from there without having to explain every little topic. So that's really great, and I'm sure that your clients very much appreciate that, of knowing that you haven't been totally corrupted by the industry, because you're not one of us, but you are one of us in terms of empathy and knowledge of what we do.
Absolutely.
We'll keep in touch, Linda. I very much appreciate it.
Sounds great.
All right. Thank
you. Take care.